There has been an outcry from many civil rights advocates for the Department of Justice to bring charges against George Zimmerman, who was acquitted of second-degree murder charges for the killing of Trayvon Martin. An investigation to determine whether or not Trayvon Martin's civil rights were violated and that he could be brought up on federal charges. Here to discuss that is former U.S. Attorney Zachary Carter. We thank you so much for taking some time to be here with us. Of course, this cry is a groundswell. More and more people are calling on Eric Holder to launch this investigation. What's the likelihood that the federal government will bring civil rights charges against George Zimmerman?
Well, first of all, I think that it is a challenge a greater challenge for the federal Department of Justice to bring charges than it was for the state. The state, even though this case may have been all about race, there was no explicit element. There was no requirement to prove that race was a motivating factor in order to convict George Zimmerman. It may have been that as a practical matter you needed to establish that, but as a legal matter it was not a requirement. Under the federal civil rights statutes, you're going to have to establish race as a motivating factor. And that's always a challenge in a society where we kind of, as I've heard one civil rights leader say, we live in the 51st state when it comes to the issue of race, the state of denial.
Sure. You know, Reverend Al Sharpton, Ben Jealous, a number of the civil rights leaders have called for this. I would imagine that the Department of Justice is not going to take their cues from civil rights leaders, but does public pressure play a role here?
Well, I think public pressure, and I've certainly worked for the Department of Justice. I mean, you wouldn't be human if you could ignore cries for help from a community that you actually came into government to serve. So, and I'm sure that Eric Holder is not going to be any different. It's not going to determine his decision, but it certainly is a motivator to try to turn over every stone you can to make sure that you've done the best possible job that you can to see whether or not you can, on the facts and the evidence that you can develop, bring a civil rights prosecution.
You know, my first question was about whether or not you think they could bring charges and bring him to federal court. It's even more difficult then to get a conviction, is it not?
Well, it's going to be more difficult because anytime race is explicitly a factor, and the jury has to determine that someone in Zimmerman's position did what he did because he was motivated by bigotry, that's always a tough sell. But in this case, there is some circumstantial evidence and possibly even direct evidence. I mean, the most important of which is the audio tape itself. I mean, I know that the prosecution described the statement that he made as being effing punks. But I think most people who listened to that tape originally before it was enhanced / possibly distorted by further forensic examination thought that it said effing coons. And unfortunately, on most broadcast networks, they haven't been able to play the unedited version of the tape, A, because of the crude expletive, and B, even when they edited out the first expletive, it obliterates the first consonant sound of the second syllable. If it is determined by the Department of Justice's own audio experts, and they have plenty of them because they listen to organized crime tapes and drug investigation tapes all the time. They have people who are truly expert in it. If it turns out that the term was really effing coons, I think that it becomes a new ball game.
That makes it look like something completely different.
Right.
When you've talked about how difficult it is. In this case, we have an individual, George Zimmerman, who was brought up on charges in the state, and he was acquitted. And it makes it difficult for them to be charged in federal court. But you've done it successfully with Limerick Nelson. Are there similarities or key differences that we can draw from and learn from in your experience?
I think that the fact that race is going to be an explicit requirement to be proved is both a hurdle on the one hand, but also a blessing in this case. I think one of the problems with the prosecution's case in the Zimmerman matter was that even though race as a practical matter was a centerpiece of what happened, they avoided explicit mentions of race like the plague, which had to leave the jury conflicted and somewhat confused. I mean, they talked about profiling, but what is profiling without the racial component? I mean, how do you understand that as a motivator? I mean, to the extent that the one juror who's been most interviewed talks about having total sympathy for Zimmerman and none for Trayvon Martin, tells you how the narrative apparently just was not sufficiently coherent that she could at least be troubled by the fact that Trayvon Martin had died tragically and have only sympathy for Zimmerman.
Indeed. And the question that we can't explore here, but we'll bring you back to talk about it later, is whether or not the Stand Your Ground should be on trial as opposed to or along with George Zimmerman. All right, Zachary Carter, thank you so much. We appreciate it.
My pleasure.
Good to see you.
Thanks.